Generally, employment is presumed to be terminable at will unless a party can prove three things. First, there was a clear and unequivocal offer of lifetime employment or employment for a definite duration. Second, the hiring agent had the authority to bind the employer to a permanent employment contract. And third, the employee who received the offer provided substantial consideration in addition to his or her day-to-day services. In Skagerberg v. Blandin Paper Company, the Minnesota Supreme Court considered whether an employee who accepted a job offer for permanent employment for an indefinite term was an employee at will. Rutger Skagerberg was a self-employed consulting engineer specializing in heating, ventilation, and air conditioning. As a self-employed consultant, Skagerberg made roughly $200 per week. And in 1930, Blandin Paper Company, a paper manufacturing plant in Minnesota, hired Skagerberg to consult on projects related to plant expansion. At the time, Skagerberg was considering taking an associate professor position at Purdue University that would pay him $3,300 per year. A few months later, Skagerberg received a job offer from Purdue that required an immediate response. Skagerberg then called one of Blandin's officers about the job offer and told the officer that it required an immediate response. The officer told Skagerberg that if he turned down Purdue's offer and purchased the home of Blandin's power superintendent in Grand Rapids, the company would give him permanent employment at a salary of $600 per month. Skagerberg intended to accept Blandin's offer and sent a letter to the officer that reiterated the offer's terms. The letter stated that the job would be permanent and that Skagerberg would turn down Purdue's offer in reliance on the officer's representations. The letter also stated that Skagerberg would buy the power superintendent's house as an accommodation. Skagerberg then moved to Grand Rapids, started working for Blandin, and contracted to purchase the superintendent's home. However, approximately 2 years later, Skagerberg was fired. Skagerberg sued Blandin in state district court for wrongful discharge and breach of contract and sought damages. Blandin filed a demurrer, or motion to dismiss, and argued that Skagerberg was only an employee at will, and therefore he could be fired for any reason or no reason at all. The court agreed and granted the demurrer. Skagerberg appealed to the Minnesota Supreme Court.